My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to inform the public. So please subscribe to our channel. A lot of times we'll get interesting calls that go something like this. A parent will call up and say, I want to terminate the father's rights. Do I need a lawyer? And it's so funny to me because the fact that they even ask the question means that they don't have to ask the second question. If their approach is, I'm going to do something to terminate the other person's rights, can I do it by myself or do I need a lawyer? They need a lawyer because they would know, and a lawyer will tell them, you can file a motion to modify parenting time. You can even file a motion to temporarily suspend it. You cannot terminate their rights, okay? You can't do that. It's customarily done through the Department of Social Services. They can file petitions based on abuse and neglect, and there might be a hearing for termination. But as competing parents trying to jockey for position, you're not going to be able to terminate anybody's rights, and therefore expectations have to be put in check. That's what you need lawyers for. Lawyers help people understand what their true rights are and what they can and cannot do, what they should expect from the court and what they might not be able to do, and it's going to be a complicated process. Typically the court is reluctant to change the rights of the parents vis-a-vis the child unless they feel that there is something dangerous to the child. In other words, just because you say something bad about you, that doesn't mean that the court's going to therefore change the parenting time. The court is well aware that people who are jockeying for position in a custody case might have some uncharitable things to say about each other. It's not going to sway the court. What the court's going to look at is what's in the best interest of the children. And if the court feels that what is being said here is important, not because it makes one guy look good and one guy look bad, but if the court feels that what it does is it bears on a security risk to the health and safety of the child, then the court will react. That's something that the court can get behind. But just, the mere mudslinging that could go back and forth where one person, says, I want to terminate her rights because said this to me or she did that. Honestly, you have to realize that the court hears it all the time. And what's very, very traumatic to you, the court already has a thicker skin because of these things. So the court is going to distinguish between what is truly an abuse of sorts, which requires the court to get involved, versus what's ticky-tacky stuff that people need to develop a thicker skin for. When the court feels it's the latter, the court's not likely to change custody. The court's likely to respond to a change in custody or modification if and only if the court feels that the best interests of the child are not being served in the existing situation. If you have questions about that, reach out and of course we'll be glad to help you out.